Honourable Dr Megan Woods.
Thank you, Madam Chair. And I think we do need to go through a number of the examples that are listed in the schedule in Part 1 of this Act to see that we on the opposition are not talking about false dichotomies. We understand the complexity of the interaction between public and private benefits. But what we have with some of the examples, Madam Chair, is actually the head-on collision of private benefit, and why this bill did need to be examined in more detail around where those private benefits were accruing. So, Madam Chair, I want to talk about the Trans-Tasman Resources application that is listed in the schedule. This, of course, a potted history that some members of this House know very well. The history of this claim had been overturned by the High Court, had gone to the Supreme Court, and it had not been allowed. But what we have is a listing of that project in the schedule of the Act. But setting aside, alongside that, Madam Chair, is that we have another form of private benefit leaving New Zealand, taking their capital in the form of an offshore wind development company, citing the inclusion in the schedule of this Act as one of the reasons why they are withdrawing their investment in New Zealand and taking it to jurisdictions where it is more welcome. So, Madam Speaker, for the Minister to stand up and say that we just don't see that there's any place for private investment is naive. Of course we do. We understand that private investment in infrastructure is absolutely necessary. The contention we have with this bill is the fact that we have such clear accrual of private benefit through the schedule, and sometimes meaning that they can leapfrog other private benefits, other people seeking to invest capital that will have public good for New Zealand in the form of more energy and electricity generation, in the form of offshore wind. So the Minister needs to actually grapple with the concepts that we're talking about here, engage with them in a mature way, rather than just dismissive headlines that we saw in that last contribution, which, Madam Speaker, although I'm giving a very specific contribution in this call, I will note how broad the Minister just took the debate in that one contribution that he gave. So an already broad stage of this bill got even broader with that Minister's contribution. The Minister has to explain to the House why it is appropriate that we are here under urgency legislating for the private benefit of a single entity that had been denied by the courts over and above another form of private investment in the form of offshore wind, which have explicitly cited the inclusion of Trans-Tasman Resources application in this bill as a reason why they're withdrawing their capital. Now, Madam Chair, one of the things that we are making very explicit, and my colleague Rachel Brooking and was at pains in her contribution and always is at pains to emphasise, is that obviously in the Labour Party we are not opposed to a process to expedite projects that we need to. Infrastructure, housing, we put one in place when we were in government, Madam Speaker, and we did it for a very good reason. We saw housing developments occur. We saw renewable energy projects go through. We saw a number of good infrastructure projects be progressed. But there is a fundamental difference with the bill that is on the table today, which is contained in the purpose statement, and it is one of the most radical unbalancing of how we think about our environment and our economy in New Zealand in decades. And I think we need to be very clear on what we're doing there. We saw the Parliamentary Commissioner for the Environment say that this goes further than the notorious National Development Act of 1979. In terms of that great unbalancing. So, Madam Speaker, I encourage the Minister and the Chair to explain to this House why it is that it is appropriate for this House to be legislating and giving the regulating making process under 61B, which gives the power to grant exemptions from the Act, why it is in Schedule 2 that Trans-Tasman resources is listed. He can't say it's not because we just don't like any private benefit, because what we're asking is, what about other private investors who are seeking, Madam Chair,
Honourable Dr Megan Woods.
other private investors who are seeking to bring their capital to this country to invest in important infrastructure like offshore wind, but have been driven out in no small part by the inclusion of a project that has been overturned in the courts time and time and time again. And that is an example that we do need an explanation on.
There's a point of order over here from, are we sure? He did call a point. Someone over here called a point of order, I believe it was.
Okay.
Thank you. Honourable David Parker.
In regard to the Minister and the Chair's comments about public or private, can I refer him to the first listed project from the Emery Irrigation Company, which is an application. It's described as being to construct and operate a ring dam providing approximately 10 million cubic metres of water storage and to divert approximately 1.5 million cubic metres of water from the Huranui River. I don't know how often, what the period is on that, whether that's over a year or whether it's per month or per week. But how can the Minister justify that sort of application being included in Schedule 2, given that the provisions of the Act deliberately exclude the participation of any environmental interest? And I would have thought that the Minister, even if he wanted to push through developments, would want to hear an environmental perspective in respect of an application to store 10 million cubic metres of water, diverting 1.5 million cubic metres of water from the Huranui River, given that that must surely have an environmental effect. Why is it that, unlike the earlier version of Fast Track, where there were some listed environmental groups who could make a written submission to the decision-making panel, such as Environmental Defence Society and Greenpeace. Greenpeace didn't actually often choose to do it, but EDS often did. Greenpeace did often, thank you. So, Madam Chair, how can the Minister justify that there is no environmental voice being listened to, whereas the development interests of the applicant, in line with the purpose of the legislation, is given such weight? Secondly, in respect of that, am I correct in my understanding that even if that was found by the Council to be in breach, or found by people looking at the application to be in breach of the regional or district plan, either of them, does the panel have the right to override the plan and give them a consent anyway, notwithstanding the provisions of the Resource Management Act, which are intended to protect the river ecosystem? And if so, how can the Minister justify that? And how can he further justify that without an environmental lobby group having the ability to even make a written submission?